Hello, and welcome to today's webinar on how to build a compliant AI program. I am Naomi Grossman, Compliance Manager here at VinciWorks, and I'm really looking forward to exploring how your company or firm can ensure that your AI program is compliant and possibly more importantly, safe. AI is no longer an emerging technology that organizations can experiment with quietly in the background. We are now firmly entering a new regulatory era. Across the EU, UK, and globally, AI is becoming a core compliance issue. It's likely to reach the same level as data protection or financial crime. In the EU, we're seeing the EU AI Act move from legislation into its implementation phase. And we have the Digital Omnibus proposal taking shape and likely changing its impact. At the same time, regulators around the world are issuing new rules and guidance on automated decision-making, on transparency, on bias testing, and on safe deployment of AI systems. Data protection authorities have also been very clear that AI is an enforcement priority. We've seen landmark cases on profiling, on training data, on consent, and there's a strong expectation that 2026 will continue to bring several major fines and enforcement actions. This webinar is all about helping you get ahead of that curve. We're going to focus on how organizations can build a safe, a practical, a compliant AI framework that supports innovation without exposing your organization to regulatory or ethical risk. First, I'd like to welcome VinciWorks Head of Compliance, Nick Henderson-Mayo. Nick is our compliance and regulatory expert with deep experience in GDPR, AI governance, and enforcement trends. So welcome, Nick.
Hi, Naomi. Great to be here.
Great to have you. And welcome to Shmuley Goldberg, VinciWorks Head of AI with over a decade of experience in implementing AI into businesses, big and small. And I know, Shmuley, you are quite passionate about AI. Great to have you here. Welcome.
Yeah, it's great to be here. It is actually a good time to be passionate about AI, not just in terms of what it can do, but actually how organizations can leverage it, and making sure they do that safely in a way that stands up to scrutiny is obviously very important.
Yeah, that's great. And it's great to have you. Now, before we dive into the regulatory landscape that's really driving all of this, let's ask a quick poll question. And the question is, how prepared do you think your organization is for AI's changing regulatory landscape? Only 3% of you are very prepared. 34% are somewhat prepared. 28% of you are aware of the rules, but you have no clear plan yet. 29% are not prepared and you're still figuring out what applies. And 6% of you are not sure. Shmuley or Nick, if you have any comments on those answers before we get started on the regulatory landscape.
I think it's really, telling that just a lot of people are really struggling to get a handle on this because there is so much change, depends so much on your jurisdiction, also what you're actually doing with AI. Are you just using a commercial AI tool like a ChatGPT, or are you building something bigger and better within your organization? So there is so much change also happening very quickly that I think is not surprising so many of us are unsure of how to even be prepared, and hopefully we'll get a little bit more clarity today.
Yeah, that's a great point, and hopefully we will be able to provide some clarity here. Okay, so let's start looking at the regulatory landscape. So Nick, one of the biggest misconceptions we still hear is that AI compliance is something separate or standalone.
Yeah, exactly. Right? Yeah, it's not happening in isolation. Most AI rules are being layered on top of existing frameworks like data protection or consumer protection or sector-specific regulation also. So for most organizations, AI compliance is really about how all of those things interact in practice.
Yeah, that's kind of how it works from a technological perspective as well. It's already how it's built, it's already how it's deployed. Systems don't live in a vacuum. They sit inside existing products, platforms that already have regulatory obligations attached to them.
Yeah, that's a really good point, Shmuley. So Nick, can you give us like the EU perspective on all of this?
Yes, so from the EU, there are three developments that are most important. And again, we're saying EU, but we also mean anyone that's dealing with EU or EU data. So it does have a broad reach. the EU rules. The first is the Digital Omnibus package, and that's a set of proposals that are aimed at simplifying and aligning this digital regulation across different areas like the data protection, with cybersecurity, and with AI as well.
Yeah, so why does that matter for AI teams, like on a day-to-day basis?
So Omnibus is really about the operational reality of it. The aim of this Omnibus is to try and reduce duplication, to reduce some of the reporting and documentation obligations, to make enforcement more consistent in general. And for those of us using AI or developing AI, it means there's clear expectations, hopefully around governance and transparency and how we evidence control, and not just through policy documents.
Yeah, it's also a bit of a signal that regulators understand that these systems are complex. It's not really about less regulation, it's more about workable regulation. So it assumes that organizations can actually demonstrate how their systems are managed properly.
Yeah, absolutely. And that second big piece is the EU AI Act itself. And that act has now been adopted, and we're firmly in that implementation phase. The important point here is that the work is front loaded. You can't really wait until final deadlines come and expect to be able to catch up.
And also the Digital Omnibus is changing the timing, isn't it?
It does. So before Digital Omnibus, the AI Act had a single hard deadline that high-risk AI systems, whether they're Annex 3 or Annex 1, had to comply from August 2026, so from August of this year.
Fully. Can you just explain that briefly? Because it gets so complicated with Annex 3, Annex 1.
Yeah, I can do. As Nick said, when we talk about high-risk AI under the AI Act, there's basically two routes in. One is Annex 3, and that's really focusing on what the AI is doing. So Annex 3 is high-risk systems that play significant roles in people's lives. Think about hiring decisions, credit scoring, biometric identification, essential services. All these fall into Annex 3, and the concern is basically the impact these systems can have on somebody else's rights and opportunities. The other path, as we mentioned, is Annex 1, which is slightly different. That's not about what the AI is capable of doing, but where it sits. So these are typical, I would say, typical AIs. These are GPTs, LLMs that are built into products which are already deployed in regulated markets. So think medical devices, think vehicles. They're considered high risk not because of the AI itself, but because they are part of a system that has very strict safety rules. And just before you answer the question, yes, there is something called Annex 2, but it doesn't really create another risk category. All Annex 2 basically is a cross-reference list. So it points to existing EU product safety laws like medical devices, aviation, toys, and explains how the AI connects into these systems. So to sum it up, Annex 3 is about risky UI. Annex 1 is about AI that is embedded in regulatory products. And Annex 2 is the bridge between the AI Act and existing safety laws.
Okay, so Nick, getting back to Omnibus, where were we?
So under the Omnibus proposal, which is taking its time going through the EU Parliament and the EU legislative process, the obligations on the annexes would only apply once the Commission has confirmed that standards are in place. And then there'll be also a short transition period. So there are supposed to be backstop dates, meaning that we aren't going to have to, we won't hopefully have to wait too long. So December 2027 is the Annex 3 high risk cases backstop date. So that should be the last time or the last moment where these things will come into place. And August 2028 for Annex 1 systems, the kind of lower risk, lower tier products.
Got it. So that kind of could give a bit more breathing room, but it also means compliance readiness kind of depends on these tracking standards and guidance, not just the calendar dates. Now, before we get to the third trend, let's turn to everyone here and ask how confident you are in keeping up with all this regulation and actually ensuring the AI systems your organization is using or developing are compliant. So the poll question is, how confident do you feel ensuring your organization's use of AI is compliant? Only 9% of you are very confident that your organization's use of AI is compliant. 30% are somewhat confident, 28% are neutral, and 27% are not very confident. 6% of you are not confident at all. And first of all, wait, before we move on though, Nick or Shmuley, anything to say about that? Are you surprised?
I mean, it's quite a broad spread, and it's kind of what I would expect to see. I think that we are still finding ourselves in this new AI world. So the fact that some people already have a good grasp on it and some people are still developing their strategy now is fair. I think it's interesting that it's almost completely flat across the board, but that just shows that we're kind of exactly in the midpoint of people seeing where we are and seeing where we're trying to go to and trying to build for that future.
Yeah,
There's
no,
a few
really,
interesting comments there in the chat. Someone mentioning they're training HR professionals in AI, so governance is obviously top of the list. And someone else is exploring how to use biometrics, which is a really, really interesting element. Actually, probably a lot of us are maybe even using biometrics and we don't realize. So if you're using fingerprint scanners for, employees signing in, potentially even, if you open a work computer and it takes a picture of your face to log you in, maybe somewhere you're actually holding biometric data. So there is a lot of kind of things that can slip through the cracks. That's why we need to be aware of all these things.
Right. Such a good point. Yeah, and perfect segue to there's just so much to know specifically about the EU AI Act, and because it is so broad and it really does, like you pointed out before, Nick, have such an impact on UK companies. Also, anyone who's using any data that crosses into the EU is going to be impacted. And we put together this incredibly comprehensive guide on AI and the EU AI Act that walks you through every part of the legislation, what it means for users, and how to stay compliant, probably most significantly. Okay, Nick, let's get to that third EU trend in AI compliance.
Yeah, so the third trend we're looking at for EU is how GDPR, the EU rule that we all know and love, how that is applied to AI. Because regulators across the EU are actively using existing data protection laws, GDPR rules to challenge AI systems, particularly around things like lawful basis for using AI, profiling, transparency, data minimization. They are doing it currently and actively right now.
Yeah, that's exactly right. And as Nick, as you're saying, compliance, it's not just one AI compliance law. One of the clearest examples of GDPR itself being used to regulate AI comes from Italy. There was the Open AI case back in 2024. The Italian Data Protection Authority, the Garante, fined OpenAI 15 million euro over how ChatGPT was operating in Europe. What's important here is why they did it. It wasn't on some obscure technical AI point. It went straight to the heart of GDPR. The regulators basically said that OpenAI didn't have a proper lawful basis for using personal data to train its models. And a lot of that data had been scraped from the internet. So individuals are never properly informed that their data might end up being used this way. So transparency was a big issue. And it also raised concerns around accuracy and around people's rights to their own data, especially when people couldn't easily correct information about themselves that was generated by the model. And even though GDPR gives individuals that right, there was no ability within the model itself to implement those changes. So there were very real concerns around this. There were concerns about minors because ChatGPT was accessible without any age verification, which meant that there's a risk of children or people being underage being exposed to inappropriate content. And what's interesting is that the Garante didn't just fine OpenAI, it also ordered corrective measures. So it included a public awareness campaign explaining how ChatGPT processes personal data and explaining really to a lot of detail what rights people have. This was a strong indication about what regulators really care about. It's not about fines and punishment. They are actually hoping to change behavior.
Wow, so interesting. And so regulators are already using GDPR to challenge AI systems on these things like training data or transparency or user rights. This is a perfect point to mention. And I saw in the chat someone asked, what does GDPR stand for? And it's General Data Protection Regulation. And we have a really quick 10-minute course that gives a complete overview of GDPR. And you can see that understanding GDPR is so relevant for all businesses. So, Shmuley, it looks like they're not waiting for the AI Act to come fully into force.
I mean, yeah, technically that's true because, yes, you're building out the AI Act today, but GDPR already applies. And regulators expect you to be able to explain how your system works. There's another story that shows that as well with DeepSeek. For those that don't remember, DeepSeek is an AI-powered chatbot that was developed outside of the EU. It got very popular very quickly because the level of efficiency was much, much greater than anything that was developed in Europe or America. It was much cheaper to deliver the same level of quality in the results. And it was being distributed through app stores across the world and especially in Europe. And this is the first time that regulators looked into a model coming from outside of the EU or US and kind of seeing where the vulnerability lies. And the big case was, again, in Italy in January 2025, very quickly to check into the handling of the personal data. And they actually ordered the app to be pulled from the app stores. And they gave the company a very short deadline to explain its GDPR compliance. Again, it didn't wait for the AI Act. They were asked to prove that they could comply with GDPR. And that Italian action actually triggered similar requests and other scrutiny in other member states, including Ireland, including, I think, Germany as well. And that shows really that GDPR enforcement can spill well across borders. What's interesting here is that regulators didn't rush straight to fines again. They stepped in early. They had the app pulled from where it was being distributed through the channels, and they wanted to further investigate the GDPR compliance. In Germany, regulators used a different kind of pressure, so it lent on platforms' responsibilities and a broader digital regulation to push Apple and Google to remove the app over unresolved privacy and data transfer concerns. So the point is GDPR is not just a set of abstract rules, and it's not just for European companies. If you offer AI services to people in the EU, you are inside the regulatory perimeter, and regulators are increasingly willing to combine data protection laws with platform and digital enforcement tools to make that real.
Okay, so we looked at OpenAI, we looked at DeepSeek, and these are examples of regulators stepping in once the concerns became kind of visible. But there's another development that shows just how quickly risk can emerge before regulators even react. And those are AI-powered browsers. So Nick, what's different about what's different here?
The differences are really dangerous from a compliance perspective. I think they should not be used along with DeepSeek, along with all of these things. And there are agents. They're like almost even imagine someone taking over your computer. Things like ChatGPT, Atlas, the Comet from Perplexity. They are not just reading web pages, they are interpreting them, they're acting on them, and that can be a bit dangerous.
You're 100% right, Nick. I think we agree with the premise. There's definitely danger there. I'm not sure we agree with the outcome. I don't think you shouldn't be able to use any of these systems, but I think you have to understand the use case. Let's start off by differentiating between traditional LLMs, which we've seen for the last few years, ChatGPT, Gemini, etc., which are built to read, interpret, and generate media, and the browsers that we're talking about, which are agentic. An agentic AI, basically, exactly as you said, can take over your browser window, can make actions, and can act on your behalf. So this is a whole new generation with new risks, new concerns, and new ways to work to make them compliant. But the impact 100% is significantly different.
Yeah, absolutely. I mean, these things, they do things like they can draft your emails, they can fill in forms, make book meetings, and do that during live sessions. So they have access to your logins, permissions, cookies, and that, as we said, is a big shift. And I think the legal risks are also really, really significant because a traditional browser will just display the content. These, newfangled agentic browsers, they will execute on actions. And that means the risk there is if there's a malicious instruction hidden in a web page, it might look completely normal, then the AI agent can treat that as something you asked it to do. So there's been a lot of cyber research on this, and they've shown that a single link or a single kind of a piece of malicious code in a website can make these browsers pull your personal information or pull other people's information that's on your computer, and then use it elsewhere, send it to places that it shouldn't be going without malware, no obvious breaches, just the AI acting on your behalf.
So it's not that the browser is hacked, it's that it just can't tell the difference between your instructions and the web page's instructions?
Yeah, exactly. And that's the big risk here, at least at the moment. And even the companies who've been building these tools, they have admitted they don't really have this a very reliable way to stop these AI agents being tricked by malicious content. So in other words, the security problems just aren't solved. And that means you could have, if you use one of these browsers that an AI is or an AI system is pushing, you can have this AI agent operating across all of your emails, all your documents, calendars, passwords, bank accounts, all of that stuff, while the security just, not necessarily where it should be at the moment.
Yeah, I agree security is lacking in that area. And I'd say beyond that, regulatorily, this is very complex. I don't have the same attitude that they shouldn't be used, but I think you have to understand that essentially this is like getting a self-driving car versus somebody driving a car. There are questions around responsibility, there are questions about access to data, and these are concerns which are 100% legitimate. If these browsers are reading behavioral patterns, if they're storing memory, if they're analyzing emails or documents to help you, that immediately raises questions under GDPR around lawful basis. So you've got other things such as data minimization, security of processing, other concerns that you need to be aware of. And if something goes wrong, 100%, as with anything else, you may be looking at a reportable breach, even though there's no one thought they were deploying a high-risk system within your company. Now, this is where it gets interesting because compliance teams can't sit and wait for guidance before deciding whether or not to use a technology and to deploy a technology like an AI-powered browser or any agentic browsing tools in their environment. These tools are shipped as experimental. They are published by the companies that produce them as experimental, and they should be treated as experimental. So if you're testing them, you have to isolate the test properly. You have to treat them like they are. My advice, and we'll talk about this more when building internal policies for this, is you almost have to treat it like you're giving an inexperienced intern access to your systems. They can do some things for you, but you should lock down them the same way you would an AI, and they should have the same access with the same level of trust.
Yeah, definitely. I mean, that's really right. But the issue about segregating those things is really important. So if you're a layperson, or you have, most of us working in the companies that we're working in shouldn't necessarily be experimenting with these things. And the risk is when something looks convenient, and people might download it, they might use it. And it's one thing if they're going to do it on a personal computer, because the risk is then they might lose, something of their own personally. The bigger risk for us as the organization is if they put it on the work computer or link somehow to our work stuff, and then we get into all these data protection risks, and we can end up losing control a little bit.
I would agree with that completely.
No, yeah, it's a really good point. And so once AI starts acting with your credentials, it's like no longer just a tool, it's part of your control environment. And I guess what you're both saying is it's something organizations really need to think about before an incident kind of forces that conversation. And I think that brings us to a broader point, because we've spent a lot of time today talking about regulation, the AI Act, the Digital Omnibus, GDPR enforcement, sector guidance in the UK, and staying up to date with all of that really, really matters. But the truth is that regulation is just moving at like legislative speed, but technology moves at product speed. And these AI browsers are a perfect example. By the time regulators begin examining these architectural risks, millions of users could already be experimenting with the tools.
Yeah, and that's why I think for us in the compliance side of things, we can't just be asking, what does the regulation say today? We do have to be thinking more about what are we comfortable deploying before regulation catches up. It sets as we know, regulation sets the floor. It'll define the minimum expectations, accountability, enforcement, all the rest of it. But it cannot and it will not anticipate every design choice, every new feature, every new thing that springs up into the market. And it definitely can't respond instantly to some of these emerging technical vulnerabilities, like we saw a perfect example with DeepSeek that we covered. It sprung out of nowhere, and then within a few days, people were already understanding that it was a risk. So that means us as the organization, we must have our own internal risk threshold beyond and apart from regulatory guidance, and be really clear about what risk we're comfortable with.
Yeah, I completely agree. I think actually that's where AI governance needs to be mature and needs to be built internally. If you're just waiting for the regulation to catch up with you, you're always going to be behind. You've got to build something and define something within your organization that can handle both. And this is leaning towards my side more, that can both handle the flexibility and the speed in the market to take advantage of technology and opportunities when they arise, but also something that means you can respond rapidly from a security and from a regulation side to make sure that you're not running behind there. If your only trigger is enforcement action, you're going to be behind. You cannot rely, in my humble opinion, on the regulators to give their verdict and to follow that. Strong organizations today build review mechanisms which evaluate new AI tools, including things like AI browsers, which is a hot topic of conversation in this particular webinar, well before they're widely adopted internally. Regulation has its limits, but it can only be a safety net, and it can't be your only one.
Great points. Like, just stay close to regulation, but don't rely on it to move at the speed of innovation. That's never going to happen. And in fast-moving AI environments, which we're in, your internal governance really needs to be ahead of enforcement and not waiting for it. So those are really important points. And this is a perfect place for another poll question. And the question is, where does GDPR cause the most practical challenges for your AI use cases? Pretty evenly split. 14% of you say lawful basis for training data is where GDPR causes the most practical challenges for your AI use cases. 15% of you say responding to data subject rights. 27% of you say automated decision-making rights. 21% of you say vendor and model provider oversight. And 23% say data minimization and retention. Now, Shmuley, do you want to answer some basic questions we have here? Like someone asked for examples of AI browsers. Can you give some of those, like examples?
There's a few examples of AI browser. The one that comes to mind is Claude for Chrome, which is Anthropic's one. ChatGPT in 5.2 thinking also can visit websites on your behalf. Firefox now have built in to their browser an agentic AI that can take behaviors for you. Chrome, actually, interestingly, Google have not released one themselves, but there are many browsers out there. And in fact, if you search for agentic browser or AI browser, you'll find that there's a whole bunch created by a whole bunch of different people. Anthropic being the big one in this regard, ChatGPT being a second one that's out there at the moment. And the challenge with all of these essentially is you can give it specific instructions. So you can say, book some flights for me, buy a ticket for me. You can say, email my boss for me. And as long as it's within the browser window, the AI is able to move the mouse, move your keyboard, send requests, send messages. It acts like a person within that browser. Claude for Chrome is probably the most popular one at the moment, but there are other ones as well. Somebody else asked about the risk of Copilot and where that sits in the spectrum. That's really, really fascinating, and I think possibly a whole other webinar. Copilot is interesting because it's bundled with and it's baked with Microsoft, which means that it actually has a lot more access to your information, but it's much less limited on what it can do. So from a GDPR point of view and a data collection point of view, the risk is quite high. But from a security point of view and a regulation point of view of it doing things for you, the risk is quite a bit lower.
Yeah, really, really interesting. So this is such a huge compliance challenge. And most specifically, you need to understand how GDPR affects AI use. And that is such a critical piece of knowledge. And we've highlighted this in this webinar, that the implications for firms and businesses are so wide-ranging vis-a-vis GDPR and AI. We have this really in-depth guide on GDPR and AI that explains every aspect of how the regulation shapes AI use in practice. And so AI compliance isn't just about model risk. It's about data governance. It's about human oversight. And it's about accountability across the entire AI lifecycle. So let's switch to the UK because their approach is very, very different.
Yeah, so the approach from the UK is different than the EU's one. There is no single AI law in the UK like the EU AI Act. And I don't think we're going to get one in the near future. Instead, the government has gone for more of a sector-led model. There's going to be existing regulators are expected to apply AI regulations to their own frameworks, like with the ICO. And that's really been the policy position since the government published what they call their pro-innovation AI regulatory approach And we've seen that kind of come through with subsequent guidance to the ICO as well.
Yeah, I completely agree. And this is something which I actually applaud the UK for. I don't often say that regulation is moving in the right direction, but I think in the UK, it's moving faster than the EU when it comes to AI. So this allows for more private innovation, more corporate innovation. By definition, it's messier for the organization because there isn't one rule book to point at, but I think ultimately it's better overall.
I mean, it's supposed to give more flexibility to respond to real world use cases as they emerge. And we have seen the British government do that. They've come and tried, want to ban Grok, and they want to kind of ban this thing and that thing, the next thing. So they are being more, I guess, driven by political decision making as opposed to a more comprehensive AI law, which again, I don't think is we're going to see in the King's speech, at least this time. But they are looking at how AI is being pulled into existing regimes like data protection, also with financial services, online safety, as we mentioned, and different rules around products.
So is this where the ICO comes in, Nick?
Yeah, and really, that's the main regulator here for the UK for AI. They have a biometric strategy also that makes it really clear that data protection law is at the core of the legal framework for AI, regardless of having new or additional legislation. So where personal data is involved, then the existing personal data protection rules are relevant. And the ICOs basically said, it's not wait and see. You already have obligations. You don't have to wait for anything. That the rules are here and they're clear. And they talk a lot about things that are proportionate, risk-based regulation. But they're also clear that organizations themselves are supposed to think about governance and accountability and have that in place now.
And then this isn't just about facial recognition or biometrics, is it?
No, those are important elements, but that gets a lot of attention. But the ICO's guidance applies really broadly to everything to do with AI and data protection and how they're interpreting the UK's data protection rules within that. So, if AI systems processing personal data, the ICO expects organizations to be able to explain what that system is doing, justify the lawful basis for it, so potentially show some documentation and show they've understood the risks and the individual's rights are still meaningful and they can apply their rights despite what you're doing.
Okay, so even though the UK does not have an AI Act, there's still quite a lot of scrutiny.
Yeah, and we see actually the same pattern with cybersecurity. We have a voluntary code of practice for cybersecurity of AI. It's not legally binding, but it is a pretty clear signal of what the government considers as being good practice across the AI lifecycle, design and training, with deployment, and making sure you've got ongoing monitoring of it as well.
Mm-hmm. But if something goes wrong, saying, "Oh, it was only voluntary," probably won't help that much, will it?
Right, and this is how the UK's approach to these things often goes. It's kind of a common law approach where you're expected to understand what good practice is and be able to demonstrate that as kind of a benchmark. So if there is a breach or there's a harm caused somehow, then if you've got a well-established good practice that follows the government's published good practice, then that is what is going to help you when it comes to these sorts of investigations. And it's really relevant where, they've got AI specific risks that the voluntary code highlights, model manipulations you've got, the security weaknesses also that might not exist in traditional software. So it is really, really useful to bring in those voluntary codes.
Thank you for that. Then we have financial services, Shmuley, where the FCA has been very vocal.
Yeah, the FCA is actually a really good example of how this UK approach works in practice. They have been very clear. They don't plan to introduce AI-specific rules. They expect firms to apply existing principles like governance, fairness, accountability, and consumer protection to their use of AI. So I think this is probably the best approach. It sees AI as what it is. It's a tool to be used by companies. AI doesn't lower or change the bar. In fact, if anything, maybe it raises it.
Wow. Okay, so when people say the UK is kind of a lighter touch on AI, that's not the whole story.
Pretty much. Like the UK might be lighter on headline legislation, but it's not in any way lighter on expectations. The UK wants to create an environment in which companies are able to make decisions for themselves as to which tools, AI or not, they use in their business. And we'll talk about this later on while we talk around building that AI compliant program. You want to focus on existing laws, companies and businesses want to be able to demonstrate that they are following those laws and that they have AI systems which are well governed, transparent, controllable in practice. There may not be a single AI act to comply with. The UK isn't there yet, and there may well never be one act, but there's very real regulatory risk for organizations that treat AI as a compliance free-for-all. So the main point across both the EU and the UK is that AI compliance has moved from theory to a practice. Whether or not there's a specific law in place, regulators expect clear ownership, real controlled evidence, the same way they would in a non-AI world. So it's not just principles or ethics statements. And the bottom line is, if you're using AI, great. That's a good thing in my humble opinion. And the questions that regulators are asking is simple. Do you understand what it's doing? And are you in control of what it does?
Great point. Okay, let's ask another poll question. And the question is, does your company provide AI awareness training? Really important. 22% of you say, yes, your company does provide AI awareness training and it's effective. 12% say yes, but it's not very effective, which is almost like a no. 48% say no, but you'd like to. 12% say no plans, and 6% say not sure. And that's kind of a perfect segue to what we're going to turn to next. And that's exactly, how do you build an AI program that's compliant and stands up in the real world?
Yeah, definitely. So it's one thing, obviously, to talk about rules and guidance in theory, but it is another to actually make it operational in a way that the regulators and auditors and even your own organization can trust.
Yeah, I think, and I mentioned this earlier, there's a very basic and simplified rule which works in the vast majority of generalized cases, which is you should treat AI like you would a new employee or an intern in your firm. You need to understand and you need to prescribe what data they have access to, what information they have access to, just like you would an employee. You have to define what they're allowed to do, what access they have, what control they have, exactly like you would with a new employee. I think this rule, it's something that we've discussed a few times, and it's something which, moving forward throughout this next section, we'll talk about a lot, is fundamentally a way of treating an AI like another element within your business that needs to be controlled, just like a human employee or any other piece of software would be.
And that's why you want compliance to be built in from the start. You really want throughout design, training, testing, deployment. Every stage should have governance and risk management built into it.
So great points. But what does that look like in practice?
I think the first thing, obviously, is to figure out the governance side of things. Someone needs to own the AI risk at a senior level, and there should be a clear approval process for any new project that's involving AI. You want to have responsibilities. You want to have oversight of our models you're using. And I think regulators will also want to see that someone is accountable and they have control and say over these things. And then that naturally leads on to risk assessment, ask the tough questions. What personal data we're using? Could the AI produce biased outcomes? What happens if it fails? And more importantly, how severe would the impact be for individuals or the business if there was an issue?
Yep, absolutely. That's step one. And once you have that risk profile in place, you move into data governance and management. And this is where you need to be aware of GDPR, UK data protection law, and any other sector-specific rules that intersect with your AI. So you've got to know where your data comes from, whether it's lawful to use, whether it's accurate and representative. If somebody exercises their data rights, you need to be able to respond appropriately. For AI, that means thinking about how you build data sets, not just as raw input, but as something that you have the ability to actively curate, document, and protect. There's also, by the way, this is also true if you're developing your own models. I don't know how many people on this webinar are building their own AI models, but if that is the case, you can't just train a model and hope for the best. Testing has to be structured. You need to do bias checks. It's really important to keep audit trails throughout this process as well. So every version, every data set, every tweak, you're logging so that if and when the regulators ask for it, you can give the information across.
Yeah, definitely really good points. And it also brings us to the fact you have to be able to explain what your AI is doing in plain language. You don't necessarily have to show somebody the code, but you should be able to understand, or they should be able to understand the logic and assumptions and limitations that are involved in that. And particularly for high risk decisions that AI might be making, that also includes a way of giving people an opportunity to question the outcomes. And that's where human oversight comes into it. AI cannot replace human responsibility. It's supposed to complement it, but critical decisions or these high-risk decisions do need people in the loop. Those are the rules, and there's a serious risk if you just kind of give AI over to all of these big decision-making issues that people the AI might be putting them through. There has to be a process for intervention from a human if the system is going off course, and something a clear way to escalate an issue if someone raises something.
Yeah, it's such an important point. A human needs to be involved in any AI deployment.
Yeah, 100%, and you cannot overlook the human element. The same way that an employee would have a manager, there would be a reporting structure, there'd be a hierarchy. You've got to make sure that those things are in place as well, as we said, for any AI that you're employing. And that means, by the way, that training is essential, not just for developers, but for anyone, compliance teams, HR, procurement, even and especially leadership. Anyone who touches AI, anyone who uses it as part of their day-to-day work, or even rarely, needs to understand the risks, responsibilities, and procedures. By the way, that's also why documentation is so important. Realistically, at the end of the day, what you can actually show to regulators, and without that, you're kind of flying blind.
Yeah, so when you put it all together, a compliant AI program isn't like a checklist. It's more of a life cycle approach. It's governance, it's risk management, it's data controls, it's human oversight, it's monitoring, and like you just said, Shmuley, it's documentation, and these are all working together.
Yeah, it's absolutely true. And you want the AI to be trustworthy, auditable, resilient, and something that works in the real world, and something your business is going to benefit from, your customers are going to benefit from, things you can actually rely on.
Yeah, that's the perfect way to put it. If you take the word AI out and replace it with software or staff or anything else, the same rules apply. AI work is great. It can be incredibly effective. It can be empowering. It can be game-changing. But like anything else that we do in our business, that needs to stand under scrutiny. And the level of scrutiny is wholly different when you're talking about an AI system.
Yeah, I guess that's what it comes down to. It has to be a program that's defensible, that's responsible, and also, I guess, that's adaptable as both technology and regulation evolve, because they are. And if you get this right, compliance becomes part of your business's competitive edge and not just a box ticking exercise. Okay, let's get to our last poll question before we get to some of the many questions we've had in. And this question is, how disruptive has AI been in your program over the past year? Only 4% of you say AI has been extremely disruptive in your program over the past year. 8% say very disruptive. 24% say moderately disruptive. 37% say slightly disruptive. And 27% say not at all disruptive. Okay, let's get to some of your questions. What are the best approaches to addressing the environmental sustainability impacts of AI as part of a company sustainability policy or strategy?
I'll take a first stab at this, but Nick may actually have better answers than me. In a nutshell, one thing which is interesting in the AI world is that nearly all the companies that provide AI software systems models actually speak openly about the amount of carbon and the amount of water used. So Gemini, GPT, Anthropic, and other ones are famously public about their energy usage. If you wanted to offset the cost of those, it's relatively easy to do because the information is in front of you. You can build calculators, ironically, with AI if you wanted to, that talk about how much AI, so to speak, you're using, what the actual environmental cost of that is. And there are a lot of ways online nowadays to negate or to subsidize those carbon costs. Beyond that, the training models themselves is vaguer, but it's roughly assumed to be a 10-to-1 approach of the usage itself. So if using an AI costs pennies, then training an AI costs tens of pennies. And if you're looking to make sure that you are minimizing the impact there are carbon offset protocols and there are carbon offset companies out there that will do just that.
Thank you. Thank you. Really great response. Okay, we have another really interesting question here. Someone writes, we've been looking at ways of getting clients consent to using AI in the course of their matter. Do you have any suggestions or advice on how to gain such consent? Nick, you want to take this?
Yeah, I actually think consent is not a great lawful basis for using AI, because consent has to be freely given, which means it can be freely removed whenever the individual no longer wants to give their consent. So let's just say, imagine you're training a whole AI model based on consent. What happens if some of those people then turn around and withdraw that consent? I mean, how do you unpick their information from that AI model? So I would strongly urge using a different lawful basis for AI. I think consent is the least effective for that one.
Well, okay, thank you for that. Okay, Shmuley, I know you're going to like this question, so I'm giving this one to you. Question is, how does DeepSeek compare with ChatGPT in terms of the way they handle personal data and compliance?
Yeah, that is a minefield of a question. I feel like,
Right.
again, that could be a whole other webinar. But in a few sentences, ChatGPT is a US-based company which is open about the data that they handle, where that data sits, and how it works. It's worth saying that they have been proven many times in the past to not be quite as rigorous as they should have been. And a lot of their data originally came from copyrighted materials, and there's lots of ongoing lawsuits around that. So even with their transparency, there's a lot of questions. DeepSeek was developed in Asia, and they are a lot less transparent about how they work. So essentially, if you're using DeepSeek online, you have no real way of knowing where the data that you're giving them goes, which is majorly problematic. However, DeepSeek can be, unlike ChatGPT, downloaded and run locally on your own machine. So if you wanted to, you can take DeepSeek, run it locally, and then the data doesn't go anywhere at all because it only sits on the one machine that you're using. So there's advantages and disadvantages to either, depending on the use case.
Wow. Okay. Thank you. It is interesting, and it really could be a whole nother webinar. We should think about that. Yep. Okay. Nick, another really good question that I think you're going to like. Does the UK's approach of regulating AI without a single dedicated AI law give businesses enough clarity?
That's a good question. I think that, look, I don't think we're going to get an AI law coming out of the British government. That's for one thing. So I think, we have the clarity we have. And I think they've been pretty clear that they're not going to bring one. And the fact that the Digital Omnibus in the EU is actually taking down some of the EU AI Act stuff. I think the EU is regretting a little bit that they moved maybe a bit too quickly. And we can also look at the US approach, where the Trump administration has essentially put a moratorium on state level AI laws because they don't want patchwork of different jurisdictions regulating things in a different way. And I think, at least in this element, the British government is probably listening a little bit better to businesses, particularly ones that are working really heavily on developing AI, that there isn't going to be additional legislation to have to deal with. And there's pluses and minuses to that, but I think the reality is that we're not going to get anything either. So we have the clarity that we have.
Yeah, I think you've answered it very well. The line, "you have the clarity you have," is perfect. I'll say beyond that, I think the UK approach allows for a lot more flexibility and efficiency. There are so many changes in the AI landscape on a daily, weekly basis. Building a single monolithic law will be out of date the minute it's published. So by allowing the FCA to step in, the ICO to step in different areas to regulate their own businesses, and beyond that to say that, listen, forget AI for a moment. You've got to follow UK GDPR. You've got to follow the UK Data Protection Act, and you work out how to do that. Essentially gives the businesses the ability to move quickly with the guidance of the government, giving the level of clarity to understand what the ultimate expectation is, as opposed to what letters of the law you need to be following.
I want to thank Nick and Shmuley for your incredible insights and expertise. And I want to thank everyone here for joining us and participating. We look forward to seeing you all again soon. And that's it for now.